And we're back. We're now in Chapter 4, Obligations of the Vendor. This is still Sales Law, and I am Attorney Matt Palu-ay. Alright, so let's start. Obligations of the Vendor. So, yung vendor, siya yung buyer. Seller. Okay, ang vendor ay seller. Ang vendee ay buyer. Okay, so walang word na vendor, vendee, seller, selly. Walang ganon. Walang selly. Vendor, vendee, seller, buyer. Okay? So, yung chapter 4, medyo mahaba ito. Obligations of the vendor divided into 3 sections. So, tatapusin natin ito. Didiscuss lang natin yung mga importante kasi medyo mahaba ito eh. Okay? So, yung obligations of the vendor, number 1, yung general provisions, dalawang articles lang yan, 1495 and 1496. Number 2, or section 2, delivery of the things sold. Ito yung medyo mahaba-haba. 1497 to article 1544. Tapos section 3, conditions and warranties. Section article 1545 to 1581. Okay, so let's start. So, chapter 4. Obligations of the vendor. Ano ba yung mga obligations na? Teka, adjust ko lang yung camera para mas malinis yan. Okay. Obligations of the vendor. This is in Article 1495, General Provisions. The vendor is bound to transfer the ownership of and deliver as well as warrant the thing which is the object of the sale. So, pag binasa mo to, dalawa ang contemplate nito. Number 1 is transfer the ownership. Number 2, to deliver the thing. Actually, may pangatlo pala. Yung pangatlo is to warrant the thing which is the object of the sale. Ano ba yung ibig sabihin ng salitang warrant? Ngayon, kapag narinig mo na yung word na warrant, parang yan yung word na warranty. Okay? Ang warranty, it's similar to a guarantee. Okay? This is, pero I just wanna let you know that this is different from yung mga search warrant or arrest warrant. Kasi yun, hindi nasakop yun ng civil law. Papasok yun sa ang arrest warrant or warrant of arrest sa criminal law, and then yung mga search warrant papasok yan sa constitutional law. Pwede din pumasok sa criminal law kapag mag-order ang judge na i-search yung premises ng isang tao or isang lugar dahil i-search yung premises ng isang lugar, hindi premises ng isang tao. Search yung premises ng isang lugar, halimbawa sabihin niya may mga drugs daw doon, may reason to believe that there are drugs, or halimbawa if you've been reading the news, may ano diyan yung isang bahay dito sa Quezon City, nagkaroon sila ng search warrant, so pinasok nila yung loob ng bahay, tapos doon nila nakita na puro mga hot cars, luxury cars, and then may mga coins na sangkatutak ng mga coins, may search warrant sila doon. Okay, so but I already digress, I'm sorry. Let's go back. Yung warrant under sales law is guarantee. Okay, to warrant or to guarantee. So the term warrant in this case is used as a verb. When it's converted into a noun, it's called a warranty. Ngayon, narinig nyo na ba yan? Oo, syempre. Kung hindi ka pa naman nakakapagbili ng mga appliances, or usually sa appliances kasi yan kung kasama mo yung mami mo mag-shopping, lagi sasabihin ng mami mo, yung aircon ba na yan, may warranty. Yung microwave, may warranty. O yung refrigerator, may warranty ba yan? Tapos sasabihin ng tao, may 1 year po ma'am, ganyan, 1 year, 6 months warranty. Basta po yung defect ay hindi po cause ng negligence ninyo. Kumbaga, yung defect is galing dun sa item mismo. Alright? Does that make sense? Kung yung mismo yung item yung nagkaroon ng problema. Okay? Pero kumari, nalaglag mo yung microwave, natural, hindi mapapasok yung warranty doon kasi negligence mo yun Bakit mo nilaglag yung microwave, di ba? Or nilaglag mo yung TV, nabasag yung TV. Hindi mo naman pwedeng sabihin na I want this replaced kasi it's still within the warranty. Ano ba yung cost ng sira ng TV mo? Nilaglag mo di ba? Hindi papasok yun sa warranty kasi wala namang negligence yung, or hindi yun fault ng seller. Okay? Okay, gets. So, let's go to the next slide. What are the obligations of a vendor or the seller? Number 1, to transfer the ownership of a determinate thing. sold. Again, a determinate thing is a specific thing, one of a kind. Number 2, to deliver the thing. Number 3, to warrant against evictions and hidden defects. So, yung eviction is papaalisin, to evict. And then, yung hidden defects, yan yung may sira, yung item na binili mo. Number 4, to take care of the thing pending delivery with proper diligence. And what kind of diligence is that? That's the diligence of a good father of a family. Now, if this sounds familiar, that's because we already discussed this previously in chapter 1. Okay? Number 5, to pay the expenses for the execution and the registration of the deed of sale. So, dito, I think this only applies if yung binenta mo is lupa. Okay? Ang seller, siya yung magbabayad ng registration ng deed of sale. Alright, 1496. The ownership of the thing sold is acquired by the vendee or the buyer from the moment it is delivered to him in any of the ways specified in Article 1497 to 1501. So Article 1497 describes actual and real delivery, and non-actual, and Article 1498 to 1501 describes constructive or legal delivery. Okay? So let's talk more about delivery. Delivery is an indispensable or cannot be dispensed with requisites for the transfer of ownership. The reason is because ownership cannot be transferred simply by mere consent. It is absolutely necessary that the object must be delivered. So, para malipat ang pangalan or ownership ng isang lupa or ownership ng isang sasakyan, dapat nagkaroon ng delivery. Alright? So, let's proceed to section 2 of chapter 4, obligations of the vendor. So, section 2 talks about delivery. So, here, we talk about the two types of delivery. Yung una is yung actual delivery. Yung pangalawa is yung constructive delivery. So, doon muna tayo sa mas madali, yung actual delivery. 1497, the thing sold shall be understood as delivered when it is placed in the control and the possession of the vendee. Okay, so kapag binigay na sa possession ng vendee, that is the time na siya ang nagiging may-ari ng item. So, ngayon, kapag titingnan mo siya, ibig ba sabihin nun, kapag hindi pa na-transfer yung item sa'yo, wala ka pang right over the property? Ang answer is, possibly you can say na wala kang right of ownership, but you have the right to possess or to own that. You have the right, let me rephrase, you do not have the right of ownership over it yet because there was no delivery yet, but you have the right to have that thing which you purchased delivered to you. So, yung right mo is to compel the person to deliver it to you. Anong tawag doon? Specific performance. Okay? So, what is this thing called tradition? It is the delivery of possession by the proprietor with an intention to transfer the property to the receiver. So, there must be delivery and intent to transfer ownership to the receiver or the buyer. Actual delivery is the simplest to understood since this involves the physical delivery of a thing and is done by passing the movable object from hand to hand. So, halimbawa, cellphone, sapatos, o kaya yung mga items sa grocery store, hand to hand yung transfer. So, yun yung tradition, which is yung delivery is actual delivery. Madaling intindihin. So, now let's go to constructive delivery. Eto na. Itong constructive delivery, maraming klase ito. So, number 1 is execution of a public instrument. Okay, ayusin lang natin yung spelling ha. Okay, then save na natin to. So, yung execution of a public instrument, yan yung execution ng deed of sale. Okay? Now, yung paragraph 2 niyan is symbolical tradition. Yan yung may symbolism na binibigay like a key. And that would constitute delivery already, like key to the house or key to the car. Number 3, traditio longa manu. Number 4, traditio brevi manu. Number 5, traditio constitutum possessorium. And then number 6, quasi delivery. Okay, so this might seem to be quite a mouthful, but madali lang ito, promise. Okay, so just stay with me for the next few more slides and I will explain it to you in the simplest manner that I could. Okay? So, next slide na tayo. Oops. 1498, this is constructive delivery through execution of a public instrument. So what's a public instrument? It is one which is acknowledged before a notary public or any official authorized to administer oath. Okay, so ang ibig mo sabihin ng public instrument is that it's a private document first, and then the parties sign it, and then they go to a notary public to have the notary public notarize it. Kapag dinotarize na ng notary public, it becomes a public instrument kasi it binds the whole world already. Kasi may blessing na ng notary public. Kung wala yung notary public, ang tawag mo dyan ay private instrument lang. Binding yan between the parties but not the whole world, and it does not bind third persons. So kapag tatanungin ka, is it better if the document is notarized or not? Then the answer is always better that the document is notarized. Para hindi pwedeng sabihin later on ng other party, ay, pinakay mo yung signature ko. Hindi ako pumapayag sa ganyan. O, di ba? Kung ganun man ang eksena, kung halimbawa, ninotarize ninyo, and then, yan yung defense ng kabilang party, hindi ko pinirmahan yan. O, di sasabihin mo, anong hindi? Nasa harapan tayo ng notary public, ko. Tingnan mo, ninotarize nga ni attorney ito, eh. So, kung gusto mo talagang, i-deny mo talaga, di magkasuhan tayo, papapuntahin ko si attorney para mag-testify sa court na talagang yan yung intention natin. So, kung ganyan, mapapatunayan natin na nagsisinungaling ka talaga, di ba? Okay, so yun lang yung instrument, yung purpose ng public instrument. So, constructive delivery applies both in both personal and real property as well, because the law does not distinguish. However, if in the contract or the instrument the parties state that there is a different date for delivery, then the property is not deemed to have been submitted. This is just, of course, the exception. So, halimbawa, nag-enter kayo ng contract of sale or deed of sale of a parcel of land. The moment na nagpirmahan na kayo, nagpanotaryo, yun na yung yun yung constructive delivery. Pero lang, of course, kung sinabi ninyo na yung transfer ay mangyayari 6 months from now, edi walang change ng ownership, walang delivery dito. Kasi walang delivery through a public instrument kasi ang mangyayari, yung delivery mangyayari sa future pa. So, hindi pa ngayon. Okay? But, siguro after yung nag-lapse yung period of time, then you can enforce yung public instrument na pinirmahan ninyo. Okay? Next. So, tradition symbolica or symbolical tradition. Constructive is delivery symbolic when to effect the delivery, the parties make use of a token symbol to represent the thing delivered. So, a car was sold, a key was given by the seller to the buyer. It's called, that's called a traditio symbolica or symbolical tradition. It's as simple as that. Traditio longa manu. The seller points to the thing which shall thereafter be the control and the disposal of the vendee. I think nanggaling ito sa mga lumang panahon eh, di ba? Halimbawa, ng mga unang panahon, ang sabi ng mga Kastila, ibibenta ko na sa iyo yung property na ito, tapos tatanungin mo, hanggang saan po ba yan? O hanggang dun sa puno ng mangga na yon, tapos tinuro niya. And then dun sa bundok na yon, pag-aari mo na yon. So, ang tanong is gumagana pa rin ba ito hanggang ngayon? Parang malabo nang maging ito ngayon. Magkaroon ng real life application itong traditio longa manu, yung nagturo ka lang. So, anong purpose nito? Well, ang sagot niya is kailangan lang natin alam for academic purposes. Malay mo later on baka magamit natin. Pero definitely, kailangan mong alamin yan kasi mag-e-exam ka di ba? Traditio brevi manu, the vendee has already the possession of the thing sold by virtue of another title. So, for instance, a lease, and thereafter, the seller sells the said leased property to the vendee. Okay, itong traditio brevi manu, napakasimple nito. Halimbawa, si A, umuupa siya ng apartment kay B. Tapos later on, sabi ni B kay A, if you want, you can just buy this property kasi I'm going to the States now, we're going to migrate so we want to liquidate. So, sabi ngayon ni A, okay, sige, I'll buy it from you. And then they executed a contract of sale. So, in this case, this is what you call a traditio brevi manu kasi yung seller, he sold the leased property to the vendee or to the buyer. And then yung buyer was already possessing it as a lessee. But then, since na-transfer na yung ownership sa kanya, siya na yung lessor. I mean, siya na yung magiging owner ng property. Okay? Next slide. Traditio constitutum possessorium. The vendor continues in possession of the property sold, not as owner but in some other capacity. So, for instance, the vendor, he owns the property and then the vendor sells the property to the vendee. But they have an agreement wherein the vendor would lease the property for say 5 years. Okay, in this case, the vendor maintains possession of the property although the ownership has already passed to the buyer. So, nangyayari ba ito sa totoong buhay? Ang sagot is, posible naman itong mangyari. Yung vendor, binenta niya yung property niya dun kay vendee, pero may usapan sila ni vendee na, pre, although binili mo na itong property na to, sa akin mo na yung possession nito, ha? Papaupahan ko lang ng 5 years. O sabi naman ni vendee, sige lang, ox lang bro, hindi ko pa naman need yan eh. Okay. So, may mga arrangement ba ng ganyan? Parang ang sagot very rare, pero nangyayari naman talaga. So, kung mangyari yun, edi at least alam mo na ang tawag doon. Ang tawag doon ay Traditio Constitutum Processorium. Lumalabas pa to sa exam? Yes, of course. I think I remember answering this in the bar exams. 1501, Quasi-delivery. This is a mode of delivery of incorporeal things or rights. Incorporeal things are things which has no material existence but exists in contemplation of the law. So this includes delivery of negotiable document of title to prove ownership, or for instance, certificate of stocks. Okay. Next. Okay. So questions na. So nasa article 1502 na tayo. I think 1502. Still continuation. Okay. So sale or return versus sale on trial. So, sale on return is a contract by which the property is sold, but the buyer has the option to return the same to the seller instead of paying the price. So, medyo, extremely favorable ito sa buyer kasi yung property, ibibigay mo dun sa buyer, pero yung buyer may option to na ibabalik na yun sa seller kaysa bayaran niya yung purchase price. To sale or return, gamitin mo muna. Kung gusto mo, dibilin mo. Kung ayaw mo, ibalik mo. Sale on trial, the ownership shall be with the seller until the same has been absolute, either by the buyer's approval of the goods or by his failing to comply with the conditions of the contract. So, sale on trial or approval. Okay, so inaantay mo yung conformity ng buyer. The ownership shall still be with the seller until the same has become absolute, either by the buyer's approval of the goods or by his failing to comply with the conditions of the contract. Okay, so ano ba yung pinagkaiba? Sale or return versus sale on trial. Sale or return, sale is subject to a resolutory condition. On the other hand, yung sale on trial is suspensive condition. So, bakit pa naging suspensive condition itong sale on trial? So, babalik muna tayo. So, yung sale on trial, the ownership shall be with the seller until nabayaran, the sale has become absolute until by the buyer's approval of the goods. So, sale on trial or approval. Okay. So, yan yung sale on trial subject to a suspensive condition. Ayan yung suspensive condition. Sa seller pa rin yung item unless mabayaran na or become absolute. The sale has become absolute either by buyer's approval of goods or failing to comply with the conditions of the contract. Okay, so ang sale or return naman is subject to a resolutory condition. Sale or return depends entirely on the will of the buyer. Sale on trial depends on the character of the quality of the goods. Sale or return, ownership of the goods passes to the buyer on delivery, and subsequent return of the goods revert ownership of the seller. Sale on trial, the ownership shall remain with the seller until the buyer signifies his approval or acceptance of the sale. Okay, sale on trial and sale or return. Again, the sale or return, the ownership of the goods passes to the buyer on delivery, and the subsequent return of the goods revert ownership to the seller. So, pwedeng i-return niya. The risk of loss rests upon the buyer. The risk of loss, on the other hand, is with the seller dun sa sale on trial. So 1503, article relates to specific goods. General rule: delivery passes to the thing sold. Delivery to the carrier is deemed delivery to the buyer. So the moment na pumunta ka na sa Philippine PhilPost, nakapag-deliver ka nun, that means na parang na-deliver mo na rin sa buyer mo yung item. Okay? Exception: there is contrary intention that appears in the contract. Okay, next slide. If the thing is lost by a fortuitous event, the risk is borne by the owner of the thing at the time of the loss. So yan yung res perit domino. And generally, after perfection, the buyer becomes the owner of the object. So if the object is lost, the buyer bears the risk of loss. So actually dito, medyo may kailangan kang i-analyze ng maayos. Kasi kapag titingnan mo, after ng perfection ng contract, the buyer becomes the owner of the object. Parang ito, medyo confusing kasi kapag kinumpara mo kanina, or dun sa sinabi natin kanina, the buyer only becomes the owner of the goods kapag dineliver sa kanya yung item. Okay? If the object is lost, then the buyer bears the risk of loss. Okay? Pero, ang paulit-ulit itong sinasabi, and then we'll go to Article 1504, ha? Sa book. Oo, normally talaga, after perfection, the buyer becomes bears the risk of loss. Exception: when the seller reserves ownership of the goods merely to secure performance by the buyer of his obligation under the contract, and then the actual delivery has been delayed through the fault of either the buyer or the seller. 1505 talks about a sale by a person, not the owner. So, let's see. 1505. Ayan. So, yung nagbenta, hindi siya yung may-ari ng property. So, yung buyer doesn't acquire no better title than the title of the seller, which is wala namang ownership talaga yung seller. So, the exceptions here: the owner of the goods is stopped from denying the seller's authority to sell. The law enables the apparent owner to dispose of the goods if he is the owner. The sale is sanctioned by statutory or judicial authority. So, number 4, sale is made at the merchant's store, fairs, or markets. Number 5, seller has voidable title which has not been avoided at the time of the sale. Number 6, seller subsequently acquires title. So, ang general rule: if the goods are sold by a person who does not own them, the buyer acquires no better title to the goods. So, yan yung general rule. Ang exception dito is, ito yung mga exception na kung saan, the goods are sold by a person who does not own them. So, the owner of the goods is stopped from denying seller's authority to sell. So, dito, ibig sabihin ay yung mga exceptions na ito, kahit na hindi siya yung the owner of the goods is stopped from denying seller's authority to sell, the law enables the apparent owner to dispose of the goods as if he is the owner. Okay? If the goods are sold by a person who does not own them, the buyer acquires no better title. Okay. So, yung exceptions na yan is the buyer will acquire better title of the goods. Yun yung exceptions. Okay? So, 1506, seller of the goods has voidable title over the property but has not been avoided at the time of the sale. So, in this case, even if the buyer brought the property from the seller with a voidable title, the said sale is still valid, provided that the sale happened before the seller's title over the property has been avoided, and the buyer buys them in good faith for value, and the buyer has no notice of the seller's defect in title. 1507 talks about documents of title. Documents of title refer to goods and not to money. A document of title is a symbol of goods covered by it. Serves as evidence of transfer of ownership, evidence of transfer of possession, evidence of contract between the parties. So there are three most common forms of title. So you have yung bill of lading, the contract receipt for the transport of goods and their delivery to the person named therein. So there are three parties. You have your carrier, your shipper. Yung shipper siya yung nagpapadala. Tapos yung consignee, yan yung tatanggap. So you have your dock warrant, instrument given by the dock owners to an importer of goods. Warehouse on the docks recognized the importer's title to said goods. Warehouse receipts, contract or receipt for goods deposited with the warehouse. And then you have your kedan, which is yung warehouse para sa sugar. So what are the classes of documents of title? You have your negotiable documents of title. You have your non-negotiable documents of title. Okay. So those are the topics. And then I think we can move to Article 1522. Ano? Let me just check the book. Okay, Article 1522 is still a continuation of Chapter 4. It still talks about delivery. So, specifically, number 1, delivery of goods less than the quantity contracted. So, if it's less than the quantity contracted, the buyer may reject the goods, or the buyer may accept the goods, but he must pay the price pro rata. Okay? Number 2, delivery of goods more than the quantity contracted. So, the same, pwede niyang i-reject or pwede niyang tanggapin na lang yung yung tama lang. Then pro rata uli babayaran niya. Delivery of goods mixed with others. The buyer may accept those which are in accordance with the contract and adjust the rest, or he may simply accept all and pay the price. Number 4, effect of indivisibility of subject matter. So he may reject all of it. Okay. 1523, delivery to the carrier is delivery to the buyer, exception the contrary of intention appears in the contract. So the seller's duty after delivery to the carrier. The fact that the ownership of the goods may have been passed to the buyer does not mean that the seller has already fulfilled this duty to the buyer. This means that there are no additional obligations that the seller must do. What are the obligations that the seller must do after delivery to the carrier? So 1523 provides that the seller must contract with a carrier on behalf of the buyer as may be reasonable under the circumstances. So the seller must give notice to the buyer regarding the necessity to insure the goods. If the sellers fail to do this, the risk of loss will be borne by the seller. So ulitin ko yung number 1 na the seller must contract with the carrier. So kakausapin niya yung carrier on behalf of the buyer as may be reasonable. So marami na palang trabaho ang seller pagkatapos niyang mabenta yung item sa buyer. So may definition tayo dito, yung free on board. It is a term in international commercial law specifying what point the respective obligations, costs, risks involved in the delivery of goods shift from the seller to the buyer. So ito, pinag-uusapan natin dito parang kung sino yung may liability habang tumatakbo yung item or yung items to be delivered. Goods are to be delivered free of expenses to the buyer. This means that the seller will assume the cost of transportation of the goods at the port of shipment. Thereafter, the buyer pays for all costs beyond that point. This means that the seller's responsibility is only until the goods are loaded on board the ship. Thereafter, the buyer assumes the risk. So, ito may example ako dito na free on board. So you have your seller, then your exporter, then you load it to a ship. Tapos yung ship to sa destination. Tapos yung destination pupunta siya dun sa buyer or sa importer. So naman yung CIF, cost insurance freight. Freight ata tayo with an E. Oops. Freight. They signify that the price fixed covers not only the cost of the goods but the expenses of the freight, and insurance to be paid by the seller up to the point especially named. Okay, so next, CIF and FOB mainly differ in who assumes responsibility for the goods during transit. So in CIF, the insurance and other costs are assumed by the seller, with liability and costs associated with successful transit paid by the seller up until the goods are received by the buyer. So dito, yung sa CIF, yung seller talaga yung gagalaw. The responsibilities of the seller include transporting the goods to the nearest port, loading them on the vessel, and paying for the insurance and freight. In some agreements, goods are not considered to be delivered until they are actually in the buyer's possession. In others, goods are considered delivered once they reach the point of destination. So FOB contracts relieve the seller of responsibility that once the goods are shipped, after the goods have been loaded technically past the ship's rail, they are considered to have been delivered to the control of the buyer. When the voyage begins, then the buyer assumes all the liability. Okay? So, kumbaga kung ikaw yung seller, mas gusto mo yung yung FOB, free on board, kasi the moment na dumaan na nalagay mo na yung item sa barko, wala ka ng obligation. The buyer can therefore negotiate a cheaper price for the freight and insurance with a forwarder of his or her choice. In fact, some international traders seek to maximize their profits by buying FOB and selling CIF. 1524. The vendor shall not be bound to deliver the things sold if the vendee has not paid him the price, or if no period for the payment has been fixed. So we're going to modify our understanding of a general contract by reading Article 1524. So in general rule, the obligation to deliver arises from the moment of the perfection of a contract. However, specifically in a contract of sale, there must be necessity of payment of price. The price must first be made before the delivery of the subject matter. This means that the buyer must first pay the seller before the seller delivers the item purchased. Ano ba example niyan? Well, siguro kung pupunta ka sa grocery store, no, dapat bayaran mo muna bago ma-deliver sa yung item. Delivery means, in a sense na nakapack na yung in-grocery mo and then ready to leave na. Parang ganun siguro. So, yung understanding mo ng contract law and our understanding of sales law, to be more specific, is going to be greatly affected by Article 1524 again, which categorically states that ang vendor or yung nagbenta, hindi siya obligado pa na mag-deliver ng item. Dapat bayaran mo na ni vendee or ni buyer yung purchase price. Okay? But there is an instance where delivery of the object must be made even before the price has been paid. Yes, the thing must be delivered even though the price has not been made if a time for such payment has been agreed upon in the contract. In this case, delivery must be made during such payment. So, for instance, si S nagbenta kay B na buyer ng horse, 30,000. Walang date for the performance of the obligation. So, here si seller, hindi siya obligadong i-deliver pa yung kabayo kasi wala pa yung bayad sa kanya eh. Okay, isang example ulit. S sold to B 30K and the payment is to be made within 2 months. So, in this case, si seller, kailangan niya nang i-deliver within 2 months. Kasi yung kabayo, kasi may naka-indicate na dapat within 2 months. Sa loob ng 2 buwan, dapat na-deliver na niya. Even though yung buyer, hindi pa nagbayad. So, kung ikaw ba yung seller, papayag ka ba ng ganyan? Ang sagot, dapat ilagay mo rin dun sa kontrata na yung buyer, dapat bayaran ka rin within 2 months. Para patas lang kayo, di ba? Malay mo, 10 years na pabayaran, di ba? Di, lugi ka naman. So, sino ba yung unpaid seller? So, ang unpaid seller is, yan yung seller na, well, unpaid o hindi nabayaran. One who has not been paid or tendered the whole price or nagbayad ng buong halaga. One who has received a bill of exchange or other negotiable instrument as payment, however, the instrument was dishonored. So, what do you mean by the seller who has not been tendered the whole price? Ang ibig mo pala sabihin ng tender, that means to offer. Nag-offer ka ng, halimbawa, tender your resignation. Ibig sabihin, nag-offer ka ng resignation. Tender payment means nag-offer ka ng magbayad. In this case, the seller has not even been offered the whole price. This means that if the buyer tendered the entire payment to the seller but the seller did not accept the payment, the seller is not considered an unpaid seller. Kasi, nag-tender yung buyer sa kanya eh. Meaning yung buyer was willing and able to pay, pero yung seller mismo yung hindi tinanggap yung bayad. So what if there's a partial payment? The seller remains as an unpaid seller. Unpaid seller still has a seller's lien or the right to take hold of the subject matter of the contract of sale until full payment of the price is delivered to him. So itong seller's lien, relate ko to sa attorney's lien. Yung attorney's lien, yan yung may right na i-hold ng lawyer yung mga documents ng kanyang client hanggang fully paid yung client sa kanyang obligation. Ganyan din yung seller's lien. The right to take hold of the subject matter of the contract of sale until full payment of the price is delivered to him. So, pwede niyang i-hold mo na yung item. Bayaran mo muna ako. Pag nabayaran mo ako, doon ko i-release. Okay? What about payments of negotiable instrument? Payments through a promissory note or check shall produce the effect of payment only after they have been encashed. Tama naman yan. After encashment lang. Okay? Kasi posible na walang laman yung cheque, di ba? Ngayon kung walang laman cheque, tawag mo doon. Well, ang mangyayari, magbabounce yung cheque. Pag nag-bounce yung cheque, pwede na maging liable yung nag-issue for BP22 or bouncing checks law. Okay? Criminal case yun, so may possibility na pwede siyang makulong. And syempre, bakit mo ipapasok yung sarili mo sa ganong klaseng scenario? Di ba? Mas okay na yung liability mo is always purely civil. Ibig sabihin, hindi ka madedemand ng kriminal. Kahit na 1 milyon, 10 milyon, 100 million pa yung inutang mo, hindi ka makukulong sa hindi pagbayad ng utang. Pero of course, in the first place, hindi ka papautangin ng ganong kalaking halaga kung hindi naman nakikita ng lender na may capacity to pay ka. Kasi ilalagay mo lang yung sarili mo sa shoes ng lender. Papautangin mo ba itong random person ng 10 million pesos kung trabaho nito store clerk lang, di ba? Paano niya babayaran yung 10 million? Parang imposible. So, hindi wise na business decision yon. So, now we've defined who an unpaid seller is. This is Article 1525. Now, put yourself in the situation of the seller who has not been paid by the buyer. So, do you have any rights? So, the answer is yes. 1526 discusses the rights of an unpaid seller. So, yung remedies ng unpaid seller is right to possessory lien, meaning the seller may possess the property until payment by the buyer of the purchase price. Tama yan. Possessory lien, yung unpaid seller, pwede niyang i-possess mo na yung item. Number 2, stoppage in transitu. Means that the seller may stop the goods in transit or on the way to the buyer. So this applies despite the general rule to delivery, that the delivery to carrier is delivery to the buyer. So if you translate this in English, yung stoppage in transitu, that means to stop in transit. Pwede mong tawagan siguro yung delivery truck or kung sino man yung magde-deliver, sabihin mo, hindi ako nabayaran, so I stopped this in mid-transit. Okay? We will continue yung voyage kapag nabayaran mo na. Siguro kung barko yun, titigil yung barko, di ba? Stoppage in transit hanggang mabayaran ka. Number 3 is the right to resell the goods. Ibenta mo yung property ibibenta mo yung property para ma-recoup mo lang yung payment mo. Tapos number 4 is the right to rescind the sale. Okay? So, i-cancel mo na yung sale kasi parang rescission pa rin ng contract kasi hindi naman siya nag-comply ng obligation niya. So, possessory lien, okay na yan. Unpaid seller contemplates the situation where the unpaid seller made the partial delivery of the item subject to the sale. Does the unpaid seller waive his right to possessory lien over the remaining undelivered items to the sale? The answer is no. The unpaid seller still has the lien of the property still in his possession in proportion to the price due to him. Okay? So when does the unpaid seller loses his possessory lien? Number 1, when he delivers the goods to the carrier but he did not reserve ownership or possession of the goods. Number 2, the buyer lawfully obtains the goods. And then number 3, the seller waives his possessory lien. Okay, ito yung right to stoppage in transitu. If the unpaid seller has already parted with the goods, he may still exercise the second right of stoppage in transitu. That is, he may resume possession of the goods while they are still in transit. when the buyer becomes insolvent. So, yung una, hindi mo talaga ibibigay yung item. Itong pangalawa, yung item on the way na doon sa pinagdi-deliveran mo, pero nalaman mo na insolvent o walang palang pera, walang pambayad naman yung buyer mo, edi sasabihin mo sa kanya, stop na muna natin yung delivery kasi total, pag dumating dyan yung aking delivery, yung aking mga items, wala ka rin naman pambayad, di ba? So, isa-stop ko na. So, how does the seller do this? Yung stoppage in transito. The seller may obtain actual possession of the goods or to give notice of his claim to the carrier currently possessing the goods. So, tatawagan mo yung driver ng truck o yung siguro yung piloto ng eroplano or yung ship captain ng barko na stop muna. Okay, pero parang hindi naman realistic masyado yung aircraft at saka yung barko, no? If you think about it. But again, this is purely theoretical. Pero yung truck siguro, parang very feasible yun, di ba? So, requisites of, for the exercise of a right in stoppage in transit to the seller is unpaid. Kaya nga, unpaid seller, di ba? Yan yung number 1 na pinaka-importante. Number 2, buyer's insolvent. Walang pambayad. Bakit mo pa i-deliver yung item sa buyer kung wala naman talaga siyang pambayad, di ba? Number 3, the goods are in transit. Number 4, the seller must either take actual possession of the goods or give notice of his claim to the carrier or person in possession of the goods which is while in transit. Number 5, the seller must surrender negotiable bill of title if one was issued, if issued by the carrier or bailee. Siguro if one was issued, the seller must bear the expense of the delivery of the goods. So, wawa naman yung seller. Siya pa yung mag-bear ng expense ng delivery. So, ano bang ibig sabihin ng in transit? So, goods are in transit or transito. After the seller delivers to the carrier or other bailee the object of the sale before the buyer accepts the delivery of them. And number 2, if the goods are rejected by the buyer and the carrier or other bailee continues in possession of them. So, yan lang yung ibig sabihin ng in transit. Okay, so 1532 again, Article 1532 explains again what are the way to stop the goods in transit. Number 1, taking of actual possession of the goods by the seller. Number 2, giving notice of claim to the carrier or bailee. Yung bailee yan yung the bailee is the person in custody of the goods in the meantime. So, the bailee's duty is to safe keep the goods. Guys, safe keep to hindi to keep safe. Safe keep, walang word na keep safe. Okay, 1533, does the unpaid seller have other rights other than the possessory lien over the item subject of the sale and the right to stoppage in transito? Yes, the Article 1533 talks about the right of the unpaid seller to simply resell the goods. So, kailangan niya ibenta yung goods kasi presumably baka yung goods ay masisira, diba? Ibenta niya na lang para kahit pa paano kumita siya at hindi nasira yung item. So, kailan ba to allowed? Ayan. When the goods are perishable in nature, like fruits and vegetables, the right of the right to resell is expressly reserved in case the buyer defaults to pay and the buyer delays in payment for an unreasonable time. Note that if the unpaid seller resells to a third person for a price lower than his agreement with the initial buyer, the unpaid seller may sue yung initial buyer or yung nauna na bumili for the balance. 1534, apart from those 3 rights, namely possessory lien, stoppage in transito, and resale, the seller has a 4th right, and that's simply to rescind the sale. Okay, so the right is available to the seller only when he has possession of the goods, provided that the right to rescind is expressly reserved in the contract in case the buyer defaults in payment and the buyer delays in payment for an unreasonable time. 1535, what about when the goods in transit were covered by a negotiable document of title? So, general rule, buyer cannot have any greater right than the seller. This rule applies if the goods are not covered by negotiable document of title. Exception, if goods are covered by a negotiable document of title such as a bill of lading, the seller's lien or the right to possess the goods cannot prevail over the right of a purchaser in good faith to whom the negotiable instrument has been endorsed. So, ito medyo tricky ito. I think you have to be familiar with the concept of a negotiable instrument and the concept of endorsement to be able to understand it. Okay? So, sa sales law naman, hindi naman masyadong dinidiscuss actually itong portion na to. But nonetheless, I took the liberty of discussing each article one by one. Okay? 1536, a while ago we discussed that the general rule is that the seller is not obligated to make delivery unless he is paid. So, hanggat hindi siya mabayaran, pwedeng hindi siya mag-deliver. An exception to this rule is when there is a period indicated in the payment, in which case delivery must be made within the said period. But, so, unang-una, ang general rule, kapag hindi nabayaran ng seller, pwedeng hindi niya i-deliver yung item. Ang exception dyan is kapag may nakalagay na period. So, even if hindi pa makapagbayad ang buyer, may obligation na siya na i-deliver yung item kasi nakalagay yun sa kontrata. Okay? But, is there an exception to that exception? So, ibig sabihin, even though there is a period indicated in the contract of sale, the seller is still justified in delivering. I think this is supposed to be justified in not delivering. I will double check that. Article 1536. The seller should not be made. Okay. Even though there's a period in the seller is justified in dapat to not delivering the item. Yan na, kasi not obligated eh. Yes, the Article 1536 provide for instances wherein the seller is not obligated to deliver the item despite the fact that there is a period indicated in the contract of sale. So, meaning even though there is a period indicated in the contract of sale, the seller is justified in not delivering the item. Okay? So, what are these instances? So, number one, the buyer has become insolvent and he did not provide any guarantee or security. So, wala nang pera yung buyer. So, number two, buyer did not furnish the seller guarantee or security na pinramis niya. Number three, the buyer's own acts has impaired the guarantee and security. Number four, the buyer violates any undertaking in consideration for which the seller agreed to pay. And then number 5, the buyer attempts to abscond. Ano ba yung abscond? Abscond means to run away. Ayaw niya nang i-comply yung kanyang obligation. So, tumakbo na lang siya. So, basically, kapag binasa mo to, yung instances na pwedeng hindi na i-deliver ng seller yung item even though may period is kapag wala ng pera or insolvent na yung buyer. Kasi common sense lang din naman yan. Bakit mo pa, kung ikaw yung seller, bakit mo pa i-deliver yung item dun sa buyer na alam mo naman yung buyer insolvent na, di ba? And wala din namang binigay na security sa'yo, di ba? 1537, vendor is bound to deliver the things sold and its accessions and accessories in the condition which they were upon the perfection of the contract. So, I think we discussed this earlier, yung mga accessions and accessories, naka-attach yan doon sa things sold. Okay? Dito na naman tayo sa usapang aso. Okay? Usapang aso at yung puppies ng aso. So, if the vendee or the buyer has the right to the fruits of the things sold from the time the obligation to deliver arises. Okay? Again, the obligation to deliver generally arises upon the perfection of a contract. So, the seller sold his Labrador Retriever to B, the buyer. While still in the possession of the seller, the Labrador gave birth to the puppy. So, who owns the puppy? So, it depends. The buyer will own the puppy, meaning kung sino yung bumili, sa'yo na yung may-ari ng puppies if there is no date for the payment. But B has already paid for the purchase price to S. So, ibig sabihin yan, kapag nagbayad na yung buyer ng purchase price, ibig sabihin may obligation to deliver na si S. Or number 2, there is a date for payment. And that period has already arrived, and then afterwards nanganak yung puppies. Okay? On the other hand, the seller owns the puppies if the Labrador gave birth before S's obligation to deliver arose. Okay, so again, titingnan natin dito, ang right to accessions and accessories will only arise kapag yung obligation to deliver has already arisen. So this means that if there is no date for payment and the buyer has not yet paid the purchase price, or there is a date for payment or the date has not yet arrived, yung seller, yung may-ari. So again, may obligation ba yung seller to deliver yung item? May obligation ba yung seller na ibigay yung aso doon sa buyer? Ang sagot, kung walang date of payment, dapat magbayad muna yung yung buyer dun sa purchase price. And this is because itong provisions ng sales law here, it discusses na kapag walang time indicated, dapat mabayaran mo na yung seller. Okay, so yung buyer muna dapat magbayad, tapos dun pa lang magkakaroon ng obligation to deliver ng item yung seller. Okay, so again, one more time for the sake of emphasis, general rule sa contract of sale tapos walang nakalagay na period to deliver is that yung buyer muna, kailangan muna niyang magbayad sa seller. After niyang magbayad sa seller, doon pa lang mag-a-arise yung obligation ng seller na i-transfer yung items. On the other hand, kapag may period, ibig sabihin nun, halimbawa yung period nakalagay within 2 weeks, dapat within 2 weeks kailangan nang ma-deliver ni seller yung item, even though hindi pa rin nagbabayad yung buyer. Okay? So, kung ikaw yung seller, anong natutunan mo dito? Well, ang natutunan mo dito is dapat sasabihin mo sa kanya parate na yung obligation ko to deliver yung item sa'yo is upon or after mong magbayad sa akin. Okay? So, bayad muna bago delivery. Okay? So, I think yan yung takeaway natin dito. Okay, next slide tayo. Okay, so wala na pala, no? Tapos na tayo. So, midterms. Okay, very good. So, this will be it for now, guys. Just want you to study all of this, and I'll send you your midterm exams. I hope you learned something in these videos that I sent to you. And hopefully yung mga walang internet connection, you find time to watch these videos that I made an effort of making for you. And as you can see, hindi naman ako very techy, so I just try my best to substantially comply with the videos and the recordings and give them to you. Alright? So with that, we will end yung first half ng semester, and I'll send you your midterm exams, and I'll see you the second half of the semester. So that will be all for now. Thank you, guys. Bye-bye.